Good morning, I'm Gary DeWaal, and this is Bridging the Week for July 15th through 19th, and today is July 22nd, 2019. The Commodity Futures Trading Commission and the Securities and Exchange Commission brought separate enforcement actions against the portfolio manager of a hedge fund for mismarking valuations of interest rate swaps in order to gain a higher bonus. In doing so, the CFTC relied on a provision of law currently under attack in a federal appeals court in California. Separately, two principals of an introducing broker and two futures commission merchants settled charges brought by the CFTC related to the IB's placement of orders for certain customer, proprietary, and discretionary accounts. The FCMs were charged with failure to supervise. The central and northeast United States sweltered under very high temperatures and humidity this past weekend. So I can enjoy the barely cooler temperatures promised for this week. Let's get started. Swapmill Reig, a former portfolio manager with Marinus Capital Advisors, settled charges with both the Commodity Futures Trading Commission and the Securities and Exchange Commission for mismarking valuations of certain interest rate swaps and swaptions from approximately June 2016 through April 2017 in order to increase his performance bonus. At the relevant time, Marinus was registered as a commodity pool operator with the CFTC and as an investment advisor with the SEC. Subsequent to Marinus recognizing Mr. Reig's purported wrongful conduct, the firm liquidated its funds, fired Mr. Reig, and reimbursed excessive fund management fees which had been assessed based on the inflated profits. Generally alleged both the CFTC and SEC, Mr. Reig achieved his purported subterfuge by manipulating an internal valuation tool used by Marinus to assess swaps and swaptions values. As a result, said the SEC, account statements provided to customers reflected overstated returns. The CFTC charged Mr. Reig with engaging in a manipulative or deceptive device or contrivance in violation of applicable law and a CFTC rule, while the SEC charged Mr. Reig with aiding and abetting equivalent violations under security laws by Marinus, which itself was not charged by the SEC or CFTC. To resolve the two enforcement actions, Mr. Reig agreed to pay a fine of $100,000 to the CFTC, $100,000 to the SEC, and disgorged profits of $600,000 along with prejudgment interest of almost $50,000 as well as other sanctions. Although the CFTC charged Mr. Reig with a provision of law that was adopted as part of the Dodd-Frank Wall Street Reform and Consumer Protection Act, a California federal district court held in May 2018 that the relevant statute, which prohibits, quote, any manipulative or deceptive device or contrivance in contravention of such rules and regulations as the CFTC shall promulgate, end of quote, only applies in instances of fraud-based market manipulation and not fraudulent conduct alone. The court took this view based on its reading of or in the statute as meaning and, which it said was supported by congressional dialogue leading to the adoption of the relevant provision. The CFTC appealed the district court's decision containing this conclusion, and the case is now pending at the Federal Court of Appeals for the Ninth Circuit in San Francisco. Two principals of an unincorporated introducing broker and two futures commission merchants that guaranteed the introducing broker resolved charges brought by the CFTC related to the IB's purported improper placement of bunch trades containing both customer and proprietary orders and discretionary trading without obtaining powers of attorney or specific authorizations from customers. According to the CFTC, from approximately January 1st, 2014 through September 24th, 2017, William Katselis and Shaheen Maleki, DBA Essex Futures, routinely submitted bunch orders for post-trade allocation that contained both customer and proprietary orders, as well as discretionary and non-discretionary orders. After the orders were executed, the IB would provide the relevant FCM with post-trade fill instructions for the proprietary accounts, the discretionary customer accounts, and the non-discretionary customer accounts. However, charged to CFTC, an IB cannot place both proprietary and customer orders executable at or near a market price at the same time. Moreover, said the CFTC, an IB cannot place a trade for a customer unless it is either specifically authorized by the client, including exact order parameters, or unless the client has provided written power of attorney authorizing discretionary trading. Both Vision Financial Markets and ADM Investor Services were also both charged with failure to supervise by the CFTC for their handling of Essex combined orders for proprietary and customer accounts and discretionary and non-discretionary trades. The CFTC claimed that both firms failed to react adequately to red flags of Essex purported wrongful conduct. The CFTC supported its claim that Vision ADM failed to supervise Essex wrongful handling of bunched trades, citing a CFTC regulation dealing with the post-execution allocation of bunched orders. The CFTC claimed that this rule, quote, places an affirmative obligation on FCMs to monitor for unusual allocation activity and to make a reasonable inquiry into the matter if an FCM had actual constructive knowledge of fraudulent allocations, end of quote. However, there's no such express requirement in the relevant rule. For more on this, check out the article version of Bridging the Week at www.bridgingtheweek.com. And finally, Facebook Libra initiative was significantly attacked last week in a speech by Steven Mnuchin, Secretary of the U.S. Department of the Treasury, and during a hearing before the U.S. House of Representatives Committee on Financial Services. I have coverage of this on my article blog, including my recollection how once upon a time commodity options were banned in the U.S. for being disruptive. Huh, you say? Check out the article version of my blog for details. Are there lessons to be learned for the current debate on Libra and other crypto assets? Well, that's it for this week's edition of Bridging the Week. As always, there's more information on each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.